Yes, then Mr. Mnisi, it's your turn.
As it is the court.
Maloi.
As it is the court, my lord. Firstly, my lord, thank you for the indulgence.
Okay.
Remember the court initially verified with me, actually wanted to find out from me whether am I opposing the application or not. Then I said no. I need to go first, read what is contained in this application by the state. Then I'll come so that I can formulate. And this is my formulation.
Okay.
I do oppose the application.
Yeah.
Thank you, my lord. Now, before I get to the reason why I am opposing the application, my lord, let me just hear certain issues that the court raised with the state when the state was addressing the court in this application. Now the court says, what I put to Mrs. Vittelingham seems to be bothering around the question of reputational damage. And the state says yes, actually it does, to such an extent that it involves all the segments that is involving the state, being the investigating team, the prosecution, and everybody else. And according to what the court has in mind, that bothers around reputational damage. But that suggestion, my lord, and I'm saying this with due respect, seems not to take into account or lose sight of the fact that what I put to Mrs. Vittelingham was not something that I thumb-sucked. It was materially based on what the state presented as documents and on the analysis of the documents that were presented by the state. And a person with a background of a criminal justice system with that information would have done a disservice to the criminal justice system as well, not to have hinted that what was reflected in those papers actually does constitute fraud. Fraud being a misrepresentation of facts. After those facts were misrepresented, they were uttered, it means they were presented. It does not end up there, my lord.
Yeah, thanks, I'm with you. So, but the fraud then, is it uttered by Steyn or is it by Ms. Vallingham?
We are not yet at that stage, my lord. We are not yet at that stage. It is not for this court to determine who made that uttering.
No, I was in this court. Ms.
Yes.
Vallingham was reading, or he was being cross-examined on the affidavit
Yes.
of Steyn.
Yes.
All I want to know was the alleged fraud directed at Steyn's affidavit or Ms. Vallingham's interpretation being cross-examined on Steyn's affidavit, or is it her own personal view and evidence under oath?
I think I made myself very clear, my
Okay,
lord,
fine.
that
Okay.
in an event that there are complaints that are going to be laid, and we're still contemplating that,
Yeah, fine.
that those complaints will be made by the compiler of that statement, which would have been Exhibit 01 in the circumstances.
And who's the compiler?
The document speaks for itself, my lord.
Is it
I need
Mr.
not speak
Steyn
on
or
behalf
Ms.
of the
Vallingham?
document. No, I'm saying the document speaks for itself.
Yeah, but I want to know, is it, who compiled the document?
The document, my lord, has been handed in as Exhibit O as an affidavit.
Of
So
who? Of
at the
who?
inception, at the very first paragraph of that document, it indicates who the compiler of that affidavit is.
Who is that?
The document, as I say,
No,
my
Mr.
lord,
Mnisi,
speaks for
you're an
itself.
officer of this court. When the court asks you a pertinent question, you've got to
Yes.
respond to it. Who is the compiler? That's all I want to know.
The document, according to this document, and that is not me saying that, according to this document, The affidavit was penned by Mr. Steyn.
Colonel Steyn, fine.
Yes. Now, as I was saying, my lord, that information is not thumb-sucked, but it is exclusively based on what is contained on the documents. And basically, a suggestion that constitutes reputational damage, that was not intended by my submission, my lord. I could not have, because reputational damage simply means to come and say something that does not exist against somebody which has got a propensity to have some negative impetus on their good reputation. But this is not the case in this case. This is what the state produced, and this document has not been produced either by the defense, it comes from the state, my lord. And further on, my lord, I heard the court said that I said the basis of the complaint will be fraud, uttering, defeating the ends of justice, and blah blah blah. I can't recall saying blah 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 blah, my lord. I was very specific. I said fraud, uttering and defeating the ends of justice.
And forgery?
No, forgery, I never mentioned
so they didn't
forgery,
forge the document?
No,
Okay,
I never mentioned forgery.
okay, fine.
Yes. Now, my lord, let me come to the reason why I say I oppose this application. Now, the court will be well aware that at the very inception of this case, from the date on which a complaint was laid about this case, the state started to do investigation with regard to the complaints that emanate from this case. It went on for some time, up until the date on which the state says, we've now got all the information which will then enable us to start to point certain fingers against certain individuals, which we then suspect to have been involved in this case. And this we are basing on the information that we have gathered up to thus far. So the state says. And indeed, what the state did after they've accumulated that information, they then decided to arraign all these 4 accused persons, the 5 accused persons that are before court here, on certain charges, and which is the reason why we're here now, here at the High Court. Now, in the process of analyzing the evidence that the state has against those that it intended to indict before this court, the state must have come across this information, and that is not a reputational damage. The state must have had come across this information such that when they then started to present their evidence, it was then incumbent upon the state to bring it to the attention of Mr. Steyn, or even before Mr. Steyn comes and testify here, and or Mrs. Vitilingam, during their consultation, if ever there was a consultation, and I do not insinuate that there was never a consultation, but a prosecutor, an ardent prosecutor, would have picked up this information even before the 2 witnesses come and testified here and took up these issues with them. And when they came to testify here, Mr. Steyn would then have been referred to this information and said, but Mr. Steyn, look, this is what Mrs. Vitilingam says. This is what the affidavit of Mrs. Vitilingam contains, and this is what your affidavit contains. What is a probable explanation for this discrepancy? Had the state done that, we would not have embarked on this exercise.
Against the deadline of
No, but I'm
cross-examination.
still addressing the court, my lord. Mr. Valoyi had addressed that. He would have an opportunity to respond. He would have an opportunity to respond. I'm not so sure whether I need to proceed or give Mr. Baloyi this rostrum to proceed, my lord, for the whole day, and then we listen to him.
Just
my lord.
proceed. He will
Excuse me, my
respond if
lord.
he wants to. You can make a note of that, they say.
Excuse me, my lord.
I say you say he will respond if he wants to.
As it please the court. Thank you, my lord. Now, it is very late for the state to come now and say, no, we want to recall Mr. Steyn to come and address certain issues which came out when Mrs. Vittlingam was cross-examined. Now, basically, all that the state is doing now is to do damage control, which is not a legal requirement for a recalling of a witness, my lord. The state did have an opportunity, on the basis of what I've just submitted, to take this aspect up with Mr. Steyn when he proffered his testimony there. For what the reason why they did not do that, I don't know. Probably the state would come and explain that when he responds. And I can only hope, and sincerely so, my lord, that the state does not come up and say that is yet another reputational damage. My lord, it is a procedure unheard of. It is a procedure which turns our criminal justice system into a hollow of mockery. What the state is doing now is requesting this court to justify or to grant an application in its favor, an application that will turn this procedure, which has been so painstakingly laid in terms of more than 300 sections in terms of the Criminal Procedure Act, where the legislature sat it down and said, this is how we're going to regulate our criminal justice system. Now the state is requesting this court to simply overlook that in the interest of administration of justice. Administration of justice, my lord, does not mean that the standing rules of procedure and protocols and conventions, which have been applicable for so many years, should simply be overlooked in the name of administration of justice. That phrase, administration of justice, encompasses or includes in its broader understanding and perspective in respect of the procedure that has been there for a very long time. As I'm saying, my lord, all that the state wants to do here, because of the embarrassment that has been evinced in cross-examination of Mrs. Vittlingam of what the state's case is all about, they're just simply in a process to do damage control. Now, as I'm saying, it is unheard of, my lord, to try and come and do damage control on an aspect of an evidence that came up when a particular witness was being cross-examined. That is best left for argument, because it is this court and this court alone, as a listener to the facts and the metric of the case, that is obligated to make a credibility finding. And more so, my lord, let me just sound a word of warning to the state that the very same process that the state is now embarking upon might come and haunt them very terribly. They are in a grave now, which is 6 feet down. They are busy digging a grave that is going to take them 24 feet down, because the reason why I'm saying this, my lord, is because ultimately the court will be called upon to make a credibility finding. Mr. Steyn would come and give a version that is different from the version that it gave initially. And I can tell you, my lord, that the state is going to find it very difficult, because we are going to have an opportunity to cross-examine him. The state is going to have a very difficult difficulty in trying to reverse all the little gains that the state has made thus far, my lord. I am saying, my lord, administration of justice does not permit a recalling of a witness to come and correct issues of contradiction that came out when a particular witness was cross-examined.
I thought Mr. Baloyi said to come and clarify. Maybe I'm wrong, but as I'm sitting here listening, I thought the application is about the clarification, not the correction.
That's just a
Okay, I'm just saying it. You can argue it further.
That has also never happened, my lord. Whether it's clarification,
Okay, fine.
whether it's clarification, whether it's correction, whether it's
not in our law.
It's an elongation. I've never said it's not in our law, madam. I'm
You say
saying
it has
that
never happened.
It has never been heard of.
That's it. It means it has
For
never
a
happened.
for a party to recall
Mm.
a witness who he has an opportunity to lead in evidence in chief,
Okay.
who also had an opportunity to re-examine that witness after that witness was cross-examined, to have a third bite on the cherry.
Okay. fine.
It's a very strange process indeed, my lord. Now, the state has referred to this court, my lord, to some authority relating to the reopening of a of a case by any party after the closure of both parties' case. Now, the state wants this court to believe that the principle is applicable. No, the principle is not applicable, my lord. The cases that the state referred to this court, in fact, the cases that the state referred to this court to are utterly distinguishable from what is happening in here. Nobody has actually closed their case here. If the state actually wants to recall Mr. Steyn, it can only recall him for purposes of new evidence. And that would basically mean that the state has got to qualify the reason for the recalling of Mr. Steyn for that new evidence in terms of the passage that the state has that the state has actually read to the court. The reason why that new evidence was not read earlier on. But that authority is not applicable for purposes of recalling a witness in order to come and clarify, so to speak, by the state, issues that emanate from cross-examination. That is unheard of, my lord, which is the reason why I am saying the state, because it's rattled in one way or the other, simply embarks on a process to do reputational damage, my lord. Now, and the reason why, my lord, I say the state is embarking on a process to do reputational damage is not far-fetched. I mean, it is not a reputational damage, damage control. I'm sorry, damage control, not reputational damage, but damage control. And the reason why I'm saying that the state is embarking on a process to do damage control, my lord, the state itself accedes to that. Look at paragraph 1.13 of the state's heads of argument. They are basically conceding that this whole exercise is for purposes of damage control. And let me read what the state says in its own heads of argument, that they are conceding that we have been rattled, we therefore want to do damage control, and this is what they say. An explanation by Lieutenant Colonel Steyn might foreclose. That term foreclose simply means to rule out or prevent the request of accused number 3 that charges be laid against the compiler of the information, saving the scarce state resources. Who said the state has got scarce resources? Who said that? Particularly in the context of a quest where this accused person, upon being convicted, they potentially facing a term of life imprisonment, and we are being told by the state that we need to save the scarce state resources by limiting the rights that is by limiting the right to a fair trial that these accused persons are having. That is very unfair, my lord. This is just a demonstration that this whole exercise is nothing else but an endeavor by the state to do damage control. Now, on paragraph 1.4 of the state's heads of arguments, this is what the state says from line number 5. Thereafter, it was put to her, that is now, I think, Mrs. Vittlingam, that accused number 3 has given instructions for criminal charges or complaint to be laid against the compiler of the affidavit. This is a very serious allegation that must be investigated. The allegation ought to be put to Lieutenant Colonel Steyn and be given the opportunity to comment. What procedure really underpins that, my lord? Because this information emanated from cross-examination, and I've already said that this should have been picked up by the state during the preparation of this case, that there is this discrepancy here, so that Mr. Steyn, when he came here and testify, he should also allude to this. But nonetheless, my lord, I haven't heard of any suggestion such as this one, that when a person who wants or when a person wants to go and lay charges against a particular person, then they need to go to him first and say, this is what we're going to do. So you therefore need to therefore you ought to have a comment or to answer to this allegation. That's not the duty of the complainant. Once a complainant identifies that a wrong has been done, there is nothing that prevents him to go direct to the law enforcement agencies to go and lay a complaint against the person who or she thinks that is on the wrong side of the law. And it will be for that forum, subsequent to the laying of that complaint, that will have to go and determine all the aspects and the dynamics of that complaint. So the state basically says that we ought, in other words, we must, as a basis of this application, that Steyn must be recalled, that we must come and tell Steyn that Steyn, we, amongst others, we consider, I think you'll be standing there, Steyn, amongst others, we are considering to go and lay charges against you, and the basis of those charges are going to be fraud, uttering and defeating the ends of justice. That's just a hogwash, my lord. Ultimately, my lord, let me say that this exercise that this state wants the court to embark upon is nothing else but to remove this embarrassment that is on their table, which is based on the discrepancies which have been identified when Mrs. Vittlingam came and testified here. She was also at pains to say, yeah, no, yeah, I smell a rat, and a very rotten rat, because of, I don't know, because of what reasons. But everybody could see that she was at pains at that meeting, that there was indeed a fraud here. I would therefore request, my lord, that there are no legal basis that this application by the state is baseless. It's flimsy. It has got no legal basis. It will be procedurally incorrect. It will be unlawful. It will be unreasonable. It will be unjustifiable, no matter how much amount of reasoning there might be for it that this application should be granted. There are no basis. I therefore request, my lord, despite the fact that the court has indicated more than once that it is averse in granting this application, but nonetheless, I still submit that it should not be granted. Thank you, my lord.
Thank you. Yes, Mr. Ngumalo?
My lord, I'm not sure whether should I proceed in the 5 minutes that I'm having before lunch.
Yeah, proceed, please. You can finish at 1:30.
1:30.